Good evening. I'm attorney Catherine Henry, and I come to you tonight to do a Michigan Supreme Court update on things. I had given some updates previously on a couple things, but I was on the radio today, uh, both with Justin Barclay on Wood Radio and then with the Up North channel for Trucker Randy. It became clear to me that some stuff I had heard over the weekend, as well as stuff that a couple of those individuals have heard, there somehow is just miscommunication about what's coming up with the Michigan Supreme Court. So I just wanted to clarify and make sure accurate information was out there for you guys. The basic point of clarification I want to make is there's a ton of cases that involve the governor for all the stuff that she's doing right now, and there should be. But the main two that I'm going to be addressing are the one, oh shoot, what's it called? Mike, can you find it, please? You had it up. Yep. Okay, so he's going to find that one. So one of the cases that I'm looking for, or that I'm talking about, is the legislature's lawsuit against the governor. That is a case that's been going through the courts. The other case that I'll be talking about is can you give me the answer, hon? Because you got it right up in front of you. The name of the case, please. Stop scrolling. Oh, now you just scrolled again. Okay. Can you scroll down then? Because that also has it right there. Okay. What is that? Yep. What's that say?
Midwest Institute of Health.
Okay. It's the Midwest Institute of Health. The Midwest Institute of Health case is where, is it? I don't know, I can't quite see that from here. He thinks I can see that far. He's really funny. There's roughly 4 doctor's offices and 1 patient that sued the governor, the attorney general, and the Michigan Department of Health and Human Services. Those individuals, they brought their case in the federal district court, and that federal district court judge said, in order for us to really handle this case, there's 2 main points that if the Michigan Supreme Court handles, if they give us an answer in favor of the plaintiffs, essentially, on either one of these 2 points, then the federal constitutional provisions or federal statutory provisions that might be involved don't matter. So if state law or state constitution can resolve the case, the federal court judge didn't want to declare, essentially, that the governor is violating the U.S. Constitution as well. That's really what it boils down to. Why declare that the governor has violated the U.S. Constitution if we can have a scapegoat, essentially, and be able to say, well, the Supreme Court has already said, the state Supreme Court has already said that she's violating the state Constitution. That's all we need to know. The plaintiffs win. End of story. That's essentially what happened. So they did a certified question. They certified 2 questions down to the Michigan Supreme Court to answer. Essentially, number 1, is it illegal? Are these executive orders illegal? And number 2, are they unconstitutional? So that's a little bit oversimplification of the question, but it's essentially the first question is just about the law and those executive orders, how they apply to the statutes involved, and the other side being the constitutionality. Is there a separation of powers issue or non-delegation issue? So those topics in that particular case are definitely ones that have been raised in the legislature's lawsuit against the governor, for sure, because basically, if any attorney is doing their job if they are suing the governor right now, they are definitely talking about how it's a separation of powers issue and how the governor's orders are illegal as well, because even if we say that those issues or those statutes are constitutional, the governor has still violated the statutes. So they're illegal. The executive orders are illegal and unconstitutional. So in any event, the legislature's lawsuit, though, let me back up. That case with the 4 doctors and the patient that is done as the certified questions down to the state Supreme Court. That is what the court is going to have oral argument heard on September 2nd regarding. And that is the case that I made the announcement the other day that I found out Wednesday night that the only attorneys to be allowed oral argument time are the plaintiff's attorney, gets 30 minutes, the governor and the Department of Health and Human Services director gets 20 minutes as one of the defense attorneys. And then the other defense attorney representing the Attorney General's office, they also get 20 minutes. And then one amicus attorney was allowed oral argument time for 5 minutes, and that was me. So that is the case I'm talking about. That is the only case being heard on September 2nd. The legislature's lawsuit is not being heard on September 2nd. Why? Well, because the legislature's lawsuit it never had oral argument in the Supreme Court. That was June 2nd is, I believe, the date that I filed my amicus brief in that case with the Michigan Supreme Court for the first time. And June 4th is the date that the order came out. The same order that accepted my brief in that case is the same order that said, but we're not going to hear this case first. We're going to send it to the Court of Appeals first. So that was June 4th. Then the briefs were filed, and I filed an amicus brief, and I want to say maybe 15 other attorneys filed amicus briefs in that case. And oral arguments were heard. No amicus parties or amicus attorneys were allowed any oral argument time. But the oral argument was heard on that case with the Court of Appeals 2 weeks ago tomorrow. And that was done by Zoom. And I believe that the Supreme Court had indicated that the Court of Appeals had to issue their decision by this coming Friday. My assumption is that the Court of Appeals is probably going to wait till Friday to issue that decision. My guess is maybe 2:30 in the afternoon. When that issue or when that order gets issued, when that comes down, the losing party is most likely going to file their appeal with the Michigan Supreme Court. I'm kind of thinking that the legislature is actually going to end up on the losing end of that Court of Appeals round, but that's not really a surprise. I could be wrong. I would love to be wrong about that, but I'm thinking they're going to lose. With that being said, it would be most likely then the legislature's attorney, Michael Williams, who would be filing the appeal with the Michigan Supreme Court. He has been very timely about his filing so far. He has briefs filed right away. My guess then is he would then probably have his brief with the Michigan Supreme Court filed if the Court of Appeals issued their decision Friday afternoon. I think by Monday, latest Tuesday morning, Michael Williams would probably have his brief filed with the Michigan Supreme Court. Again, all just assumptions on the data and information I have so far and the things I've seen so far. I could be totally off about that, but that's my best guess. My assumption is that the Governor's Council has also been doing a good job about having fairly quick responses in this case, at least with the legislature. So I'm thinking that latest Wednesday or Thursday, probably Thursday of next week in this hypothetical scenario is when I would expect that the the Governor's brief would be filed in the Michigan Supreme Court. At that point, somewhere in all that, the Michigan Supreme Court, they're going to decide whether they're even going to take the case. But then, and that's an application for leave to appeal. That's the stage of the case. Once it has been accepted as a case to be calendared and scheduled, essentially, that's the next set of things, right? So in the application stage, amicus briefs are welcomed and encouraged. But also, if it gets to the point of having a typical calendared case that goes the normal lengthy period of time of appeals, amicus briefs are also welcome during that point. I'm guessing that Michael Williams and actually the governor's attorney, I'm guessing that all involved are going to argue that the Supreme Court needs to hear this issue right away. And I agree. This is enough. We need to get our freedom back right now. We need to stop waiting for all these other things to take place before other people in the government start holding our governor accountable and our attorney general accountable and the Michigan Department of Health and Human Services director and all the rest of them. We need to start holding them accountable now. And we need to make sure we're getting back to freedom, especially with school starting and the whole mask. Oh, I'm not even going to go there. So I'm thinking it's very likely that the Michigan Supreme Court will in fact accept the case. And I'm also thinking it's likely that they will issue their decision in a very timely fashion, not forcing it to go through the typical slow process that an appeal would normally do. So that's my best update on where we're at in terms of the Michigan Supreme Court. Now, mind you, that track is happening. Let's see, that would be, this week is the 21st. So yeah, so all of that I just said, as far as the filings of briefs and everything, if that all happens essentially throughout the course of next week, that would end up being before the September 2nd oral argument day. Whatever they decide on September 2nd, well, here's the thing. They're not going to decide anything on September 2nd. I don't think. I would love it if they did. But those arguments are already going to be made September 2nd, and the court is already going to be in the process of making those decisions. So long term, what happens on September 2nd is definitely going to impact what's happening in the legislature's lawsuit against the governor. Because let's put it this way, if the court is still taking under advisement the issue of the legislature's lawsuit with the governor, let's say they haven't had oral argument on that yet. But in the meantime, they come out and issue a decision on the legality and constitutionality of these executive orders in general. If the court comes out and says, yes, these executive orders are illegal, and yes, those statutes and doing executive orders according to the terms of those statutes is unconstitutional, the issue of the legislature's lawsuit against the governor, it's basically decided. The executive orders are illegal and unconstitutional at that point. And that is a decision that would carry all the way through all the cases all across the state of Michigan. So with that being said, I think I kind of gave enough of a, as far as before I look at questions, I feel like I said enough of an update. Does that sound like I did to you? Okay. Sometimes I feel like I said more than I did, and I just wanted to kind of get another opinion on that. Okay. And look at that. 2 minutes ago, somebody was asking about that very thing, so I think I answered that. Actually, can it be? I don't hardly see any questions. Do you? Okay. Well, that was my whole update. I don't have any more update to do. I know you guys are probably used to me doing 45 minute to 2 hour video, Facebook lives, but that was it. I just wanted to make sure that the information was out there and accurate. I did talk about that last week. The thing is, I was misinformed. I don't even remember about the context that I said, but the person in, I believe it is Tennessee that I was talking with, he's not an attorney. So I'm not sure. He works with attorneys across the country on various issues. I don't remember the context in which I brought him up, so I don't know if that changes anything. If the Midwest wins, are all the executive order restrictions lifted? Yes, definitely, they will be lifted. If that case is if the decision comes out in a way that I am thinking it will, and definitely that it should, then yes, all the executive orders would be gone. And what happened at the Court of Appeals? Nothing yet. The Court of Appeals is still thinking about it, and they just haven't issued their decision yet. I feel like these popped through after, because these are really asking. Are you seeing what's popping through, hon?
Yeah.
I'm having a whole bunch of questions all of a sudden pop up now that I just finished saying something about these. So I'm thinking there's something weird with Facebook Live. So I don't want to just repeat myself over and over again. So hopefully you guys did in fact have the answer provided to you about the time right after you would have posted that. Whoa, okay. Okay, so that is a tough one. The question that's being asked now is, if the executive orders get lifted, could our kids go back to school mask-free? In general, yes. The hard part is, and this is why it's so important that we don't focus on, oversimplifying any of this. So just kind of like how I've been saying the 1945 repeal is, it's not bad. It just doesn't do it doesn't do enough to solve the executive order problem. So if, for example, the court, for some weird reason, came out and said, yep, the 1945 law is unconstitutional, and that's all they said, well, she still has the ability to... Can you help monitor those? It's getting too hard for me to do that and answer. Okay. So if the Supreme Court came out and said the 1945 law is unconstitutional, but the 1976 one is totally okay, I don't see how they could do that. But if they did, that would have the same effect as us repealing the 1945 law and leaving the 1976 law. There's still a way to have the executive orders on the books then. The other side to that is, let's say the court actually gives us the full win in terms of specifically addressing the questions asked by the federal district court. The questions asked specifically talk about the Emergency Power of Governor Act of 1945 and the Emergency Management Act of 1976. That's it. So if the Supreme Court of Michigan comes out and says, yep, those two are unconstitutional, yep, she even violated those two anyway, so they'd be illegal, period. If that's where they leave the analysis, then we're going to have a problem. So that would be the same effect as if we only repealed the 1945 law and the 1976 law. Why would that be a problem, to just repeal those two, or just have the court declare those two unconstitutional? The court, the governor is not just using that. The governor is using a heavy hand of what's available to her in Chapter 333, as well as other areas of laws. Basically, the Public Health Code is the biggest... the other tool she's using that's of biggest influence. So if the court does not touch the issue of other action that's unconstitutional right now, that's being done through the public health code, then we're going to have problems. Or if we, let's say, Unlock Michigan repeals, they do the 1945 repeal petition, and let's say, unbeknownst to me, they've already been working on the 1976 repeal, and so they have that one coming out soon too. Let's say we go ahead and have both statutes repealed. That's not going to stop the governor in her tracks, because she still has the public health code and these other things that are at play here. That's why it's so important that we realize this is not, I know people want Cliff Notes. I know people want the Staples Easy button. But do you want the truth? Or do you want something that's just easy and it gives you an answer right now, but it doesn't actually solve your problems? That's where we're at. So to the extent that either the Supreme Court only answers the constitutionality question for those two statutes and that's it, or we get those two statutes repealed and that's it, we're still in a tough spot. We need to address the entire constitutionality of a governor utilizing any statute, or basically any government official, governor, attorney general, legislature, whatever. If any of them are infringing upon our constitutional rights, or they're trying to proclaim some additional powers are somehow given to them, or our constitutional rights are somehow set aside during a time of emergency, that needs to be declared not true, unconstitutional. So that no matter what statute is being used, it's blatantly obvious, no, you don't get to override our constitutionally protected rights, nor do you get to ignore the constitutional restraints and limitations placed upon that government power. That's what we need to have happen. That's why, number one, I hopefully will be able to end up arguing that at the Michigan Supreme Court, and hopefully they will make a decision on that point. But number two, the Restore Freedom Initiative petition, that's what that addresses. So we can go ahead and have a bunch of different petitions that repeal one law at a time, and that's fine. You guys should sign those. But if you're thinking that's the way to stop these executive orders, or to stop government overreach, or to stop the issue with, your children being required to wear masks in school or on the bus, think again, because that's not going to do anything to stop her. That's why we need the Restore Freedom Initiative petition that will stop all of the insanity, all of it. Every single thing that's happened so far is going to be stopped dead in its tracks as soon as the Restore Freedom Initiative constitutional amendment is voted on by the people and become part of the Constitution. All of this ends forever in the state of Michigan. Period. I can say that unequivocally, without any doubt. So that's why it's so important to get that big picture concept. Anyway.
Can the Court of Appeals extend their time to respond past Friday? And also, why do you think the legislature is going to lose in the Court of Appeals?
Okay. The question about if the Court of Appeals can extend the deadline to have their decision issued by Friday. If I'm remembering correctly, that was actually a directive given by the Michigan Supreme Court, then no, they can't change that on their own. That comes from their bosses, essentially. That comes from the Michigan Supreme Court. The funny thing is, I don't recall actually seeing the original order providing that the Court of Appeals had to issue their decision by August 21st. I saw it referenced in a dissenting opinion from one of the Michigan Supreme Court justices, like in a different context. And he said, I at least, something to the effect of, I am at least, thankful that we have that deadline in place, but I still think the Supreme Court should take the case right now, or something like that. And so I was like, oh, okay, well, obviously I missed an order that came out that required that to be done. But I still have yet to see the actual order. That was just referenced in a dissenting opinion attached to another order that came from the Michigan Supreme Court. Why do I think the legislature is going to lose at the Court of Appeals level? Has nothing to do with Michael Williams' job as an attorney arguing or the briefing or anything like that. I was listening to the questions of the justices, or excuse me, of the judges involved, in between hearing the one judge's fire alarm, or excuse me, smoke detector go off intermittently throughout the proceedings. And one judge really was hammering home the questions that I thought really made the point. Another one of the judges, there were three, another one of the judges, I forget the way she said it, but she came out and said something several times about, well, I don't really think it's a problem that whatever. Or I think we can all agree that there's whatever. And so the few times that she came out and said that as part of her question to one of the attorneys, I was like, whoa. So basically, I forget what it was, but it was something that she's basically saying, I agree with the governor's position on this point. So given that, why don't you answer this question for me? And I was like, yikes, that's terrible. So I wish I could remember exactly what it was at that time, but I don't. But I could be wrong because Judge Stevens with the Michigan Court of Claims at the lower level in this case, when she was questioning the legislature and the governor's attorney, the line of questions was spot on. And it became super obvious to me very quickly. She knew exactly what was going on. And she flat out said to the governor's attorney, yeah, that's about the worst argument you have so far. Or, you know, I think you're missing the point on this particular issue. She said a few things like that, anyway. Lost my train of thought. I could be misled. So I could be off in that regard. I just think given the setup, given the scenario, given the questions, just seemed more than likely the legislature is going to lose to some degree, at least at that level. But I could be wrong. Are there anything else?
Can MDHHS issue health emergencies if the EOs are shut down?
That's a complicated question, but basically the underlying question is, can the Michigan Department of Health and Human Services, or even the local health departments, can they do things related to this COVID-19 crisis if the executive orders are essentially stopped dead in their tracks? The answer is yes. The public health code, some of those very provisions that I've talked about in other videos, have nothing to do with whether a state of emergency has been declared. So, yeah, it's going to be a problem if we're only getting rid of the 1945 or the 1976 law. I wish I had another answer for you. But that, unfortunately, is the way that it is. That's why we need to have the Supreme Court issue a more overarching decision that says this is unconstitutional and this is why the government is not allowed to fill in the blank, right? The government's not allowed to infringe upon our liberties, period. The government's not allowed to assume or take over or give themselves additional powers in times of emergency, period. The Constitution, the terms of the Constitution, the state constitution and the U.S. Constitution, they mean what they mean. They mean the same thing that they meant back then. They mean that now. This is not some malleable document that just kind of changes with the, the winds of public, you know, desire. It's a contract that we literally base the whole foundation of our government upon. We need the court, the Supreme Court, to come out and say something that big, that bold, that accurate, that widespread, in order to make sure that we're actually stopping the nonsense. Any other questions?
Can the legislature change the public health code?
Oh, the legislature can certainly change the public health code. Absolutely. But they are currently listening to Republican leadership and to their, legislative council that either doesn't know what the heck they're doing or they're corrupt. So they could have been doing things from the very beginning, but again, they have those same people, the legislature has those same people in place giving them their advice now that told them in the first week of April, oh, we really need to go ahead and extend the state of emergency at least the one time. So that way we have a good argument to make in court. Guys, clearly that didn't work, did it? So anyway, do I hold my breath that the legislature is going to do the right thing? No, because what they could do is go into session and get rid of the 1945 law, get rid of the 1976 law, get rid of all of those provisions of the public health code that infringe upon our rights, which quite frankly are very numerous. I've only talked about 2, but there's a ton out there that infringes upon your rights. You just don't know that they're there. All of them need to go. And yes, the governor would veto it. So yes, they would need to be prepared to start rallying the troops and get a supermajority to override her veto. Or we could try to do things the whole, initiative route. But in any event, it can happen, yes. Any last?
You have answered this at one time. How can the governor get an emergency hearing to close down a business? But this is phrased, but we are stuck with cruel and unusual punishments.
I'm assuming the hearing that you talk about was actually one that was done through the criminal case against the barber, Carl the barber. If that's the case, the reason why that had a higher priority is because it was a criminal case. It's not a civil case. In a criminal case, the criminal case docket always has a higher priority than the civil case docket, because somebody's life, limb, or property is already being recognized as being on the line. And especially if somebody's incarcerated or, they're being locked up while they're waiting for their trial, that receives an even higher level of priority by the courts. That's why. So if people are expecting quick returns on these civil cases, it's just not going to happen. Not as quickly as it would have to happen in a criminal case. So quite frankly, some of these issues, if the courts don't get stuff moving in the right way in a quick enough time, perhaps going the route of bringing these issues up in a criminal case would be the right way. So if you know of somebody who has fought one of these executive order misdemeanor citations and they lost, or perhaps they won and the prosecutor appealed, let me know. I'd love to get involved with the appeal. That's going to be one of the best ways to have the case and the issues fast-tracked. Anything else? No? Okay. I do see one last question. I'm not sure if I missed the context. Oh, okay, I see the Well, I might be still missing context. I think there was clarification provided that the emergency hearing or the quicker hearing was held regarding when the gyms filed lawsuit against the governor in federal district court. And again, that's a federal district court thing. It's not some sort of special treatment here. There's a whole bunch of those pieces that were missing. So it's just not an apples to apples question. The Michigan United for Liberty case against the governor, I honestly don't know where that case is at. I'm not sure if anything else is happening there. And the question about the militia, we do need a well-trained, well-regulated body within the citizenry. Absolutely. In fact, as more and more people are getting denied their proper medical treatment from emergency rooms and primary care physician offices and everything else because they medically cannot wear a mask, and then they're being denied emergency treatment, either related to the reason why they can't wear the mask or a totally unrelated reason. That's completely unacceptable. What is the recourse in those situations? To go and fight it out in court? Well, we just talked about the speed at which the court is handling these things, even in a criminal case. I would suggest, and I just found this out this weekend, that some or all of the militias are getting positioned in a way that they can survive essentially without needing the additional outside resources. So for example, I believe this to be true. I don't know for sure. I believe that there are people within the militias who are, they receive special medical training, or maybe they're already medically trained in a, their day job, so to speak. And that they would be able to provide care to the militia members who needed it, who were being denied care by the typical hospital scenario. Again, I don't have the specifics on that. I might be saying all of that wrong. My point is, there's some crazy stuff happening in our world right now, and one of the best ways that we could stop the government abuse and government overreach is if we're fighting it on all fronts. Don't put your eggs all in one basket. I totally 100% believe in the Restore Freedom Initiative constitutional amendment petition, but it's going to take us 425,059 good signatures to get it on the ballot, and that ballot's not going to happen until November 2022. So I'm not putting all my eggs in that basket because it's going to take a lot of time to get us there. That's why I'm fighting all these things in court right now. That's why I'm trying to find any kind of other solution or ways to work through this in the meantime. And I would suggest the same thing to you guys as well. So, go ahead and get signatures, circulate the petitions. By all means, circulate that 1945 petition, circulate the Restore Freedom petition. Do not circulate the civil rights petition that's being out there. That definitely does not do what you think it'll do. It definitely does not increase religious freedom in any way, shape, or form. So if you do come across that one, you can ask me about it, but hopefully you're seeing this video right now and you can understand that it's bad, and I've done a video about that. But, aside from going out there and getting signatures, do those other things. Go ahead and, take a concealed carry class. Get trained to become a member of one of the Michigan militias. Support your local law enforcement officers who are standing out there doing their job while making sure that no matter what directives they're given from above, they are still abiding by the U.S. and Michigan constitutions. Support those people. There's a lot of different ways that we can make sure we're fighting the good fight right now. So, are there any last questions? Okay, so, again, I just happen to notice there's more of a comment that basically somebody can't wait to see the governor lose her executive order privileges and how is she going to sell that to her followers. Again, if she loses that ability to have the 1945 or the 1976 statute providing that emergency executive order power, she's going to just go right in. I mean, she's not going to skip a beat. She's going to immediately be geared up and ready to go under our public health code. So that's what the problem is. Our public health code is set up so that they can take you, transport you, observe you, diagnose you, and treat you, and do all of that for up to 6 days without you even ever having a hearing with a judge to argue that they shouldn't be able to do that. That's what our public health code currently does. The public health code, what's the other piece to that? Oh yeah, the public health code also allows health officials to issue orders that have nothing to do with a state of emergency, but they can issue orders to supposedly stop us from assembling and stop us basically from gathering in any kind of way. And in those particular statutes, there's no exception for, at least like with the governor's orders, there's these proclaimed exceptions about election activities or, going to church or those kinds of things. There's no exceptions written into that statute. That statute's just entirely unconstitutional, top to bottom, start to finish, but it's on the books and has nothing to do with the power to do an executive order the way that governor has been using them. So we need to make sure we're on top of this, that we are well aware that the fight is bigger than just one statute or two statutes. The fight is far worse than that. It goes to the whole concept of how our government has been accumulating this stolen power from us for decades. And it's all starting to just come to light right now. How does the Restore Freedom Initiative address the public health code overreach? A lot. It handles it in a lot of ways. First of all, let's go to, again, this is all off the top of my head. So if you are following along with me with the petition and I'm not saying any of these sections right, forgive me, but I'm already late for dinner. So I'm not going to go stop and pull out the petition, but I want to say Article 1, Section 17, I amended of our state constitution so that the only way that our government can deprive us of our life, liberty, or property isn't just simply with the phrase that we're given due process of law, because what does that really mean? No, it means with that amendment in place, it spells out that the government will not be able to deprive us of life, liberty, or property without due process of law, which necessarily includes the government being the requesting party, that they have to show beyond a reasonable doubt that it's necessary to deprive you of that life, liberty, or property because you are denying somebody else of their life, liberty, or property. If you're not denying somebody of their life, liberty, or property beyond a reasonable doubt, then the government can't deny you of yours. So, masks. The argument out there is, well, you have to wear a mask because, you're going to make people sick. There's no way, no one would even remotely argue, even from the governor's office, that they could prove beyond a reasonable doubt that someone not wearing a mask is imminently harming or threatening someone else's life, liberty, or property by not wearing a mask or a face shield. What they're doing by requiring the mask and then possibly the face shield alternative and to have a doctor's note or any of these other things that are coming out is to put the burden of proof onto the individual who's trying to exercise their rights. No. So that's the very first way. The other way is, I want to say, Article 5, Section 51, it rephrases things so that the legislature is not mandated to make laws regarding the public health of the people, but rather it allows for them to do so. But when they do that, they cannot make any laws on public health that basically have any kind of requirement where there's any kind of likelihood that it's going to be harmful to someone's health. So, for example, wearing of masks all day long is actually harmful to everyone's health, but it's at least likely to impact the health of those with asthma, those with PTSD, those with any kind of other issue like that. So, because it is at least likely that that requirement could harm some individuals, that would not be allowable with this constitutional amendment in place. Additionally, Article 4, Section 27, maybe, there's a provision in there that says if the legislature is trying to pass any kind of law that regulates the people and not just the government, in other words, the government can regulate itself all day long, right? If the government wants to say to another part of the government, you can't do this, or you have to do things this way, okay. But to the extent that the legislature tries to regulate the people and make some sort of restriction upon us, the only way that they will be able to do that would be, under this amendment, to have a 2/3 majority in the House and Senate, 2/3 majority, or they can put it up for a vote of the people to be passed by 2/3 vote. If they can't do that, then it doesn't get on the books. And to the extent that any current laws, including provisions of the Public Health Code or the 1945 Emergency Powers of Governor Act or the 1976 Emergency Management Act or administrative rules and regulations that were supposedly properly codified into state law or anything else, to the extent that the government, the legislature, has created rules and regulations for the people in the past and have not been, it has not been done by a supermajority, a 2/3 vote, those provisions would not remain in place. Let's see. There's another piece that came into mind. Oh, yes. The governor is attempting to utilize all these extraneous resources, right? So to take away your license for your business or your liquor license or anything like that, and then when it's done, these emergency orders that were issued by the Department of Health and Human Services explain you don't get your day in court if you don't like what they've done. They take it summarily, like they just take it without any hearing. And then if you want to have a hearing, you have a hearing in front of an administrative board, essentially, a non-elected set of individuals. The whole thing is being taken care of or handled start to finish, and stripping you of your license, start to finish, is really being handled by people who are non-elected public officials. By the way, those same individuals did take an oath under the U.S. and Michigan Constitution. Let's see, was it, I think Article 6 of our U.S. Constitution and Article 11, Section 1 of our state constitution that require people in the legislative, executive, or judicial branches, in order to serve in that office, you have to swear an oath to uphold the U.S. Constitution. And of course, the Michigan one requires them to swear the same oath to uphold the Michigan Constitution. Those people did it as well, even if they weren't elected. But clearly they're not. But under the Michigan constitutional amendment, the Restore Freedom Initiative constitutional amendment, all administrative agencies or administrative officers or, administrative rules and regulations, all of that, excuse me, ceases to have any kind of regulatory effect upon the people. What does that mean? None of those procedures would apply. Those administrative agencies are not going to be able to hold a hearing to strip you of your license. If there's any kind of hearing that's going to be had to strip you of your license, it's going to be done in a court of law, and Oh, I'm back. Okay, sorry. My whole computer froze. Um, that if people are given that opportunity to fight that in a court of law, let's bring us back to Article 1, Section 17, that the only way in a court of law, or really in any context, it doesn't say it has to be only in a court of law, but the only way the government is going to be able to take away your life, liberty, or property, like your business license or your liquor license, is if you have you're currently threatening to imminently take away somebody else's life, liberty, or property, or you have just done so. You know, so if you have murdered somebody, the government is able to step in and be able to take away your life, liberty, or property, as long as they have met that burden of proof by proof beyond a reasonable doubt, right? But so to answer the question about how the Restore Freedom Initiative constitutional amendment petition is going to stop these executive orders, stop the government overreach, stop the ability to utilize the the public health code or any other statute to take away your rights. Hopefully that answer that I just gave you is enough to get you going and to understand it's definitely not going to happen anymore at all as soon as this Restore Freedom Initiative constitutional amendment petition is put in place. There's other provisions that will also help with that regard, but that's just what I got off the top of my head tonight. So, honey, please tell me that that's it.
Yeah,
I know it should be it. Okay. I think those are all the questions. You have two exhausted and super hungry people. So where can you sign the petition? Okay, that's the last one I'll answer. You can sign the petition by finding the signing location or signing event nearest you. If you go to restorefreedomkh.com, that's restorefreedom, K as in Catherine, H as in Henry.com. And yes, the old link, restorefreedommi.com, still works. But this is the official blend of the Restore Freedom Initiative constitutional amendment petition and the legal advocacy work done through the Catherine Henry PC law firm. So restorefreedomkh.com, click on that. You can go to where to sign, and that tab will give you our events. It'll give you a list of static signing locations where you could just go into that business anytime that's indicated on that list and be able to sign that way. Or you also can see the list of our captains. If there's just nothing anywhere near you in either of those situations, you can go to the Contact Us page and click on Captains, and you can find the captain closest to you, and they can help you get connected with the circulator nearest to you. So absolutely, that is where you can sign. So you are welcome, everyone. I guess my husband just posted the link, so I didn't need to go into all that description on how to find it. But anyway, thank you so much, everyone, for staying informed. And those of my core team that have been on this page, on this video, commenting and helping in other ways. I will see you all bright and early tomorrow morning at 7:45, as we usually do. And I hope you all have a wonderful evening. Can we list signing events on your website? Okay, that's for real going to be the last question. Hi, Dwayne. If you want to list a signing event for the Restore Freedom Initiative petition, all you have to do is go to our events, go to the same place on our website where all the events are, click Submit an Event. That form that you fill out will make sure that we do have, in fact, accurate information, and that we get it listed to both our website as well as to our Restore Freedom Initiative calendar of events on this Facebook page. So that will make sure that it's on the official Facebook page, which will also then get it linked to other different groups and things. And a lot of the bigger events are also being advertised, paid advertising by some of our volunteers. But it'll also get it on that website. So that is definitely the one easy one-stop shop to be able to do that. Again, thank you so much, everyone. Have a wonderful night. And I don't even know if this fits in with the topic of the week like I'm supposed to be doing. I just realized that it was a big concern that we needed to get addressed. So I may talk about it in other context later on this week. Otherwise, I might go back to the shorter videos to give you a sneak peek about the topic for later on in the week. Thank you so much, everyone. Have a great night.